with respect, the assets that the Second Circuit pointed to were not the assets that the government now seems to be wanting to have this court recognize with respect to the right to control theory. I'm looking at the actual opinion in this case where I guess it was Judge Chen maybe wrote the opinion in the Second Circuit, and it says this court has endorsed a right to control theory of wire fraud that allows for conviction on a showing that the defendant, through the withholding or inaccurate reporting of information that could impact on economic decisions, deprived some person or entity of potentially valuable economic information. So it seems as though the asset that the Second Circuit was focused on was potentially valuable economic information. Am I wrong that that's what they thought the right to control theory was about?
Well, Your Honor, I think if one looks at the entire opinion, which I know we all have, it's hard to come away from that. I mean, maybe you can pick out a specific sentence, but it's hard to come away from the opinion with any impression that the Second Circuit thought this case was about something fundamentally different than what I described.
But you're describing the asset as the actual contract, as the money that was tendered in this transaction. And I didn't understand that to be what the right to control theory was about from the Second Circuit's perspective. So I guess I just don't understand. It seems as though you have reinterpreted right to control to be the new theory of fraudulent inducement in a way that the Second Circuit did not seem to put that theory forward, and that's what we thought we were taking in the context of this question presented.
Well, Your Honor, I fully acknowledge that we're not thinking about this the same way as the Second Circuit, and for the reasons I was explaining to Justice Thomas, we do think the Second Circuit has developed a way of thinking about this that puts everything in the property element that's not the right way.
And Mr. Dreeben says that's the way you argued the case below. So suddenly now we're at this stage with a reinterpretation by the government of what right to control means. And why isn't that a sort of a forfeiture from the standpoint of, if the court disagrees with you that right to control equals this transaction, or even if we don't, haven't you put forward a case that was based on the Second Circuit's conception? And that's how it was argued to the jury. That's how the jury decided it. So why isn't Mr. Dreeben right that if we disagree with that conception of the theory, then we have to reverse?
Well, Your Honor, the jury was instructed on the language of right to control assets, and both the jury's instructions and deliberations, as well as the Second Circuit's consideration of the case, occurred against a backdrop factual context where everyone understood the undisputed fact that what was really at issue here were lucrative government contracts. And that's why the Second Circuit goes on to reject the idea that there's any dichotomy between the bid rigging process and the award of the actual contracts. If the theory were as broad as the sentence that Your Honor read suggested, there'd really be no need to do that because you deprived it of economic information simply by rigging the bid rigging process. Instead, the court makes clear, and this is at footnote 9 on page 22A of the petition appendix, that one of the reasons why this is fraud is because it was an essential element of the bargain, which I think maps directly onto what materiality would require in this context. And that's because it was incorporated into the notice to proceed that the parties entered into, which is a contract that committed LP Ciminelli to spend $3 million in funds and the state to repay those funds. And then the notice to proceed was later incorporated into the final contract itself. Those are at Joint Appendix 125 and 134, respectively. So I think in the particular context of this case, and fraudulent inducement cases generally, there's not going to be a lot of argument over whether there is underlying property at issue. I think where the Second Circuit's theory is problematic is both, as I said, in moving what really is part of the materiality inquiry in the particular context of contracting, and moving that into the property element, and then potentially outside the context of fraudulent inducement cases, you could get circumstances where the Second Circuit's theory could be applied too broadly if you take loosely language like Justice Jackson appropriately just pointed out. So we don't object if what the court wants to do, and frankly what we'd urge the court to do, is to explain that the Second Circuit may not be thinking about this in the most precise way, in the most traditional way. What we would very much object to is something that suddenly erects the harm requirement that the court firmly dispensed with in Shaw, where it not only rejected the harm requirement in that case, it adopted Judge Learned Hand's formulation that fraud can exist even where there's a quid pro quo. It pointed to Carpenter as an example of not requiring harm, and Carpenter is a case in which the victim, the Wall Street Journal, wasn't economically harmed at all. And third, it actually definitively resolves the false pretenses debate that petitioner wants to have once again when it interprets false pretenses not to require this kind of harm. And if you want to look at examples of how the kind of thing I described as pedigree fraud was covered at common law, I'd encourage the court to look at some of the turn-of-the-century cases at pages 753 to 754 of the Prosser treatise, which is cited in our brief. One of those cases, Hedden against Griffin, is a case by the Supreme Judicial Court of Massachusetts at a time when I believe Justice Holmes was on that court, although he didn't write the opinion. And in that case, the victim was tricked by the defendant into thinking that a bunch of his friends had bought a particular type of insurance, and in fact, they liked it so much they didn't quite buy the company, but they became members of the board of directors of the company. He himself bought the insurance, realized he'd been tricked, and the court acknowledged it was a perfectly valid insurance policy. He just didn't want it anymore because now he'd been tricked. It wasn't what he actually wanted. He was really depending, and it was an essential element to him, that the friends have bought it and that the friends were on the board of directors. And the only measure of damages in that case was the small premium that he had already paid. And he got a full refund and a rescission remedy. There are other examples of it, like the cases at page 19 and 20 of our brief, where, for example, there's a misrepresentation to a buyer that a family member wanted the buyer to buy this particular item. That is not harm in a property interest, or if petitioner would recharacterize it as such, I really think that we're slicing the conceptual bologna so thinly that it's transparent.